What happens when two parties of a contract disagree? What happens when one party to a compact believes several of the other parties violated the rules of the compact? In both cases, the first answer is sue in a competent court of law. That's exactly what happened when Texas sued Pennsylvania, Georgia, Michigan, and Wisconsin over their handling of the 2020 presidential election. As with so many things these days, it's the details that matter. So let's look at the details of this suit next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution and we teach the rising generation to be free. I am glad you could join me. I'm going to ask you to take this video, take the recording, the podcast, the article, and share it with others. You can find this material at the website, constitutionstudy.com. There's all that information is there, and it is free for you to use. It is free for you to share with friends, family, with anyone. Use it to help educate yourself. Use it to help show other people what's going on and help all of us learn to defend and assert our rights. Now, you might want to sign up for the newsletter because I have some interesting plans coming up for early 2021. I don't know I'll get them all ready for January 1st, but I'm trying very hard. And the newsletter is the first place to find out. Just click on the newsletter. And by the way, for signing up for the newsletter, you're going to get a free gift. That is, Read the Constitution in 30 days. It's a neat little devotional designed to help you read and reread the Constitution so that you know what your rights are and you recognize when they are violated. So with that, I've got some more information I'll give you at the end of this episode, but let's get into this Texas case. When I first heard of this case, I was excited. It was presented as a state defending itself from the violation of the agreement between the states we call the U.S. Constitution. Sadly, that excitement quickly turned to disappointment as I read the complaint and the eventual response from the Supreme Court. From the complaint, quote, pursuant to 28 U.S.C. section 1251A and this court's Rule 17, the state of Texas respectfully seeks leave to file the accompanying bill of complaint against the states of Georgia, Michigan, Wisconsin, and the Commonwealth of Pennsylvania, collectively the defendant states, challenging their administration of the 2020 presidential election. The first step in any suit is to determine if the court has jurisdiction to hear the case. Now, while Attorney General Paxton refers to United States Code, the authority to hear the case comes from Article 3 of the U.S. Constitution. Quote, the judicial power shall extend to all cases in law and equity arising under this Constitution, including to controversies between two or more states. So the federal judiciary is the proper place for this case to be heard. And since the case is between two or more states, the Supreme Court has original jurisdiction, meaning the case does not go to a lower court first. Quoting from Article 3 of the Constitution, in all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. Reading from the Texas complaint, quote, our country stands at an important crossroads. Either the Constitution matters and must be followed, even when some officials consider it inconvenient or out of date, or it is simply a piece of parchment on display at the National Archives. We ask the court to choose the former. I have said the same thing for years. Either the Constitution means what it says, or it's useless. While this crossroads is not new in our history, just take a look at the Illinois election for presidential elections in 1960. The breadth and scope of what happened in the 2020 election does appear quite momentous. Quote, lawful elections are at the heart of our constitutional democracy. The public, and indeed the candidates themselves, have a compelling interest in ensuring that the selection of a president, any president, is legitimate. If that trust is lost, the American experiment will founder. A dark cloud hangs over the 2020 presidential election. Now, once again, we see a politician and lawyer misidentify our nation as a democracy rather than a republic. That aside, it is a salient point. Without lawful elections, no republic can stand. Unless the vast majority of the people believe the election was handled lawfully and fairly, distrust and unrest are the expected outcome. Just look at the last 4 years, with media, pundits, and politicians alike claiming the 2016 election of President Trump was illegitimate. While no evidence produced has survived scrutiny, The unrest, not to mention the time, effort, and money spent on pursuing those claims, has greatly impacted this nation. What will happen to this country when it is not just the politicians and media who do not consider the president legitimate, but a significant percentage of the populace? A dark cloud indeed. Quote, "Here is what we know. Using the COVID-19 pandemic as justification, government officials in the defendant states of Georgia, Michigan, and Wisconsin, and the Commonwealth of Pennsylvania, collectively defendant states, usurped their legislature's authority and unconstitutionally revised their state's election statutes. They accomplished these statutory revisions through executive fiat or friendly lawsuits, thereby weakening ballot integrity. Probably the strongest case A.G. Paxton could make was that the defendant states violated Article 2, Section 1, Clause 2 of the Constitution of the United States. Quote, each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. Now, the language is both simple and supposedly binding. The legislature of each state determines the manner of appointing electors. It should not matter whether the actions of the state's executive or judicial branches strengthened or weakened ballot integrity. It should not matter that this was done in response to COVID-19. Why it was done has no bearing on the fact that branches of these states usurped the constitutionally based authority of their legislature to determine the manner of appointing electors. Sadly, this strong argument was immediately diluted by the rest of A.G. Paxton's argument. Quote, finally, these same government officials flooded the defendant states with millions of ballots to be sent through the mail or placed in drop boxes, with little or no chain of custody, and, at the same time, weakened the strongest security measures protecting the integrity of the vote, signature verification, and witness requirements. By changing the focus from the issue of the usurpation of powers to one of how the election was conducted, A.G. Paxton made this an argument not about adherence to the compact that is the Constitution, but about who would be president. He further misdirects the attention of the court by focusing on the evidence of potential fraud. Those, however, were not the only issues in this case. Quote, however, 3 U.S.C. Section 7 requires that presidential electors be appointed on December 14, 2020. That deadline, however, should not cement a potentially illegitimate election result in the middle of this storm, a storm that is of the defendant state's own making by virtue of their own unconstitutional actions. A.G. Paxton then makes two important errors about the Constitution. First, while Congress does have the authority to determine the dates of both when the electors are appointed and when they vote, 3 U.S.C. Section 7 does not determine the date for appointing electors. Neither is December 14th the date set by law. 3 U.S.C. 1 sets the date for appointing electors as the Tuesday after the first Monday in November, November 3rd in 2020. And 3 U.S.C. 5 gives the states until 6 days before the electors vote, set by 3 U.S.C. 7, to resolve any controversies. That's December 8th and December 14th, respectively, in 2020. Quote, this court is the only forum that can delay the deadline for the appointment of presidential electors under 3 U.S.C. Sections 5 and 7. Second, and I believe the more fatal mistake A.G. Paxton made, was to ask the court to delay the voting of the electors. A.G. Paxton was asking the Supreme Court to do exactly what he accused the defendant states of doing, getting the judicial branch to usurp the power of the legislative. In this case, the setting of the date for the electors to vote. Quote, in a presidential election, the impact of the votes cast in each state is affected by the votes cast for the various candidates in other states. The constitutional failures of the defendant states injure plaintiff states because the right of suffrage can be denied by a debasement or a dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise. That, by the way, is from Bush v. Gore in 2000. In other words, plaintiff state is acting to protect the interests of its respective citizens in the fair and constitutional conduct of elections used to appoint presidential elections. My disillusionment in this case was complete by the impact A.G. Paxton claimed for the state of Texas. Once again, he focused on the elections rather than the constitutional violation of the manner used to appoint electors. As I read the SCOTUS opinion, I was not surprised either by their dismissal of the case or by the reason given. From that opinion, quote, "The state of Texas motion for leave to file a bill of complaint is denied for lack of standing under Article 3 of the Constitution. Texas has not demonstrated a judicially cognizable interest in the manner in which another state conducts its elections. While I believe every state has an interest in ensuring that the other states follow the Constitution in all respects, A.G. Paxton's focus on how the defendant states conducted their elections rather than their violation of the Constitution led the court to this most reasonable opinion. Now, while Justices Alito and Thomas believe that the court should have at least heard the case, I believe the die was cast by A.G. Paxton in his complaint. I do not know why A.G. Paxton took the course he did rather than what I believe to be the obvious constitutional issue at hand. He clearly states that parties in the defendant states other than their legislature interfered with the manner of choosing electors for the presidential election. Instead, he focused on internal irregularities, some of which may have resulted from that illegal interference. Now, as the court noted, what A.G. Paxton was asking them to do was interfere with the internal elections of other states, something the state of Texas has no legal authority to request. The state of Texas does, however, have an interest in ensuring that all parties to the Constitution follow it as the supreme law of the land. Even if the court had seen the constitutional issues A.G. Paxton hid within his voluminous complaints about how these states conducted their elections, it could not have given him the remedy he wanted. At best, the court could have found that the elections did not meet the requirements of the U.S. Constitution and ordered the defendant states to appoint electors based solely on the laws created by their states' legislatures. If the states could not or would not conduct their elections within the requirements of the Constitution, the court could have found those elections spoiled, thereby giving Congress a legal basis with which to reject appointment of those electors and their votes as being unconstitutional. Now, that would have meant that the 62 electors from those states were not legally appointed, dropping the total number of electors needed to win the presidency from 270 to 239. According to the 12th Amendment, quote, "The person having the greatest number of votes for president shall be the president if such number be a majority of the whole number of electors appointed." What does this mean for the Republic? Unfortunately, we will never know what would have happened if the court had the opportunity to opine on the merits of a state suing another state for violating the Electors Clause of the Constitution. While that opinion may have had an impact on who will occupy 1600 Pennsylvania Avenue on January 20th, the damage to the Republic was done long before Texas filed their suit. No matter who is eventually declared the winner, half of the nation will believe the election was stolen. And regardless of who wins, that half will be correct. The theft was not merely the office of president, but as A.G. Paxton put it in his complaint, the loss of trust in our elections means the American experiment in self-government has faltered. And while I am sure we will spend the next 4 years hearing the blame placed on every member of government someone can think of, the ultimate responsibility for this failure is ours. As George Washington said in his first inaugural address, quote, "And since the preservation of the sacred fire of liberty and the destiny of the Republican model of government are justly considered as deeply, perhaps as finally staked, on the experiment entrusted to the hands of the American people, it appears that we have failed in the trust we were given. The most important question now is, what will we do about it? Will we take responsibility for those we hire to represent us in all levels of government? Will we take steps ourselves to remove those who betrayed their oaths to the constitutions of their states and the United States? Or will we passively watch while our nation burns? For as Alexander Hamilton said in Federalist Number 28, quote, "If the representatives of the people betray their constituents, there is then no resource left but in the exertion of that original right of self-defense, which is paramount to all positive forms of government." So as if 2020 wasn't bad enough, we have to wrap it up with this banana republic-like election that we call our presidential election this year. No matter who ultimately occupies the White House on January 20th, Our nation, our republic, our very lives and freedoms have been damaged. How do you trust an election with so much evidence of potential fraud? How do you trust an election with voting machines that we now have evidence can change the votes? If you vote and someone can change your vote, how do you trust it? I've talked before about the issues with mail-in and other remote types of voting where there's no chain of custody. These are all problems. And this isn't a question of Trump versus Biden. This is a question of freedom and liberty. This is a question of whether or not government serves the people or the people are servants of government. If we can't trust an election for president, how do you trust an election for senator or representative or a member of your state's legislature? Heck, how do you trust an election for dog catcher or other county office? Problems with our elections are nothing new. They've been decades, and we've been told over and over and over again that it wasn't big enough to change the outcome. Well, as often happens, little problems become big problems, and now we have a big problem. And rather than looking for someone in government to fix it, it's about time we, the people, said, we will fix it. Now, hopefully you'll do a little bit like I am. Find out if your state uses a voting machine where the votes can be changed or the machine itself is connected to the internet. And go to your representatives and demand, don't ask, demand that those voting machines be outlawed. If I can't trust a machine to positively record my vote and not change it after the fact, I cannot trust that machine. I cannot trust any election based on that machine. Let's go in and fix some of these voter laws. Let's require, whenever possible, a positive chain of custody from the time a ballot is issued to a time a ballot is recorded and beyond changing. Let's make sure we have audit trails. You want to use an electronic machine to make life easier, fine, but there has to be a positive audit trail after the fact. Now, I live in Tennessee. In my county, we use electronic voting machines, but I still don't trust them 100%. What I want to see is I want to see a voting machine where I go in and I cast my votes and then it says, okay, and it prints out a paper record of my votes. Doesn't have any identification on it, just this voter, this anonymous voter voted for these people for these offices. If that is correct, if the paper matches what I did, I hit okay and it gets recorded. If not, I hit no, a poll worker comes up, destroys that piece of paper, and I continue with my voting. When I'm done, I hit okay. I hand that piece of paper to the the poll worker so that it can be kept as an audit trail. And now I have a form of voting that I can trust. There's a chain of custody. There's an audit trail. Until we demand that, I don't mean suggest it. I don't mean ask for it. I mean demand it. If you want us to vote for you for office, you need to make sure that the voting is fair and free and anonymous. And if you won't do that, you're disqualified for office. If you won't give us what we need to have free, fair, and lawful elections, you're not qualified. You're not worthy for office. I could call you names, but you're just not worthy for office. And it's about time we started holding them accountable. Otherwise, this idea of a banana republic election every 2 to 4 years will keep going and going and going and going. And we will never know when it got big enough to change the election because we'll never look into it. If you're looking for the courts to save you, if you're looking for the politicians to save you, good luck. It ain't going to happen. So as we head into 2021, let's learn from 2020. Let's get ready to make some changes, and let's do so in a way that protects the rights and freedoms and liberties of all Americans. Let's do so in a way that doesn't matter what party the victor is in, but in a way that protects the rights of all Americans. So again, head over to the website, constitutionstudy.com, sign up for the newsletter. You'll get a free gift. You'll be informed of new information as it comes out. And you can follow the new tools I'll be releasing early next year. Again, share all this information, share it from the website. I'm still having problems with Facebook. So if you're looking for me to be active on Facebook, I'm not at the moment. Still have YouTube, still on Rumble, still on Parler, looking at some others. But I hope that you will look at 2020, you will learn from it, and I hope you'll come back so we can learn some more as we go into the next year, right here on the Constitution Study.
There's one thing you have to know wherever